It is an honor today to speak right after an inspiration, Mr. Baldevraj Mahajan, a living legend and still at this point in time, one of the most hardworking lawyer in our court, my elder brother, Mr. Padamkant Dwivedi, and Think India, an organization which is encouraging debates in the legal fraternity. I've been assigned with a task to talk about the Places of Worship Act 1991. Friends, on 11th of July 1991, when President Ramaswamy Venkataraman made a declaration in the parliament, in the joint session of the parliament, that there will be a law which will be framed where there will not be a conversion of any place of worship henceforth. He must not have thought that many law students, lawyers, on this day, on 20th of May 2022, would still be talking about this law. The fact that we have to talk about it today, and not just us, the entire nation, the Honorable Supreme Court, courts at Uttar Pradesh, courts at Varanasi, every single lawyer is talking about it, every single law student is talking about it, reflects that the purpose with which, the object with which the act was framed somehow failed miserably. If we see, to begin with, I must tell you how this entire, we all know, even people, somebody who's a law student who's just passing out must not be born at that time when 1991, I was perhaps just 8 or 9 years of age, but we know what was going on in our country. The President of India, the then President of India, Honorable President Ramaswamy Venkataraman, made an announcement in Parliament in the joint session on 11th of July 1991 that there will be a law restraining the conversion of the Places of Worship Act. And the date was announced. That cutoff date is very dear to all of us, 15th of August 1947, the day which we celebrate every year, all this while, and continue to celebrate. That was the cutoff date which was decided. 18th of, after this was announced, 2 months time, 9th of September 1991, the act was presented in Parliament. Very next day, the Parliament passed it, the Lok Sabha passed it, and then it, on 12th of September, it went to Rajya Sabha. On that very day, the Rajya Sabha passed it. It received the assent of President on 18th of September 1991. With that stroke of signature, the President of India, the Parliament, conferred a dictate on 89.13 crore people of India that if there is a judicial, if there is a historical wound which is there, if there is any act which they intend to challenge in the court of law, they would be forbidden from doing so. And not just those 89.13 crore people, they're all coming generations, including us. The fate was sealed. It is important that today, when the Honorable Apex Court was hearing the matter, which we all know, the Honorable Supreme Court held that Places of Worship Act, if I can rely on the streaming of one of the leading law reporting site, it says that the ascertainment of the religious character of a place cannot be barred by the Place of Worship Act 1991. I'm quoting Law Beat, which was reporting the live conversation, what was happening. As Mr. Mahajan, the senior counsel, just said that we cannot rely, we got to know, we have to wait for a written order what transpired. But friends, we must understand what is the object of the act, what the statement of object and reasons which was going on in the mind of the legislature when this law was framed. I'll read it to you. I did not make a PPT presentation deliberately. I know it bores you all. So I'll try and make it as interesting as I can. It says, in view of the controversies arising from time to time with regard to conversion of places, it is felt that such conversion should be prohibited. The second statement, in order to foreclose any controversy in respect of any place of worship that existed on the 15th day of August 1947, it is considered necessary to provide for the maintenance of the religious character of such place of worship as it existed on 15th day of August 1947. As a consequence thereof, all the suits or all other proceedings pending as on 11th day of July 1991 with respect to any of such places of worship may abate and also further suits or other proceedings may be barred. I, as a lawyer, pained with one aspect that a law prohibits the, the entire concept of coming to court for redressal of controversies. The entire principle of judicial review. A first year law student, when he goes to the school, when a law school or a national law school, he's taught that judicial review is one of the basic structure of Constitution of India. If you have an issue still fighting on a road in a road rage case, a person can say, I'll see you in a court. He trusts courts, but it is expected out of 1991 Act that people should not come to court. If they have come to court, the suits would abate. If they have not come to court, they can never come to court. And I'm sorry that the word used is controversy. If a controversy, friends, goes on for 300, 400, 500 years, it doesn't remain a controversy. It is a bleeding wound. And that must be addressed. And can be addressed the entire concept. A foreclosure is thought of. A foreclosure is thought of. It is attempted by this act by 8 sections, one of which was repealed in 2001. The idea is that there would be a foreclosure. But what is this foreclosure without any adjudication? Why any individual cannot come to the court and can ascertain the true character of a place of worship? I am not, as a lawyer or as a student of law for all times to come, I cannot defend or argue about any particular community. That is not the brief which is assigned to me today. But what shakes conscience of an individual like me, or must shake conscience of every law student, is that can we say after reading this act that judiciary is still one of the pillars of democracy? It hit right at the bottom of that pillar of democracy, where the concept of judicial review is given a go by. All this while we have had laws like Securitization and Reconstruction of Financial Assets Enforcement Act 2002 bars the jurisdiction of civil law. Civil services rules bar certain kind of adjudication. Consumer protection laws, Money Laundering Act, they bar that proceedings cannot be initiated in civil law, but they do provide a forum. You cannot say, after reading this act, how would you teach in a law school that ubi jis ubi remedium? If there is a dispute, if there is a right, there has to be a remedy. But here, the remedy is foreclosed. I have high aspiration from the fact that in March this year 2022, the vires of this particular act was challenged in Supreme Court, and the Supreme Court has issued notice in the matter. There are fairly arguable points which deserves consideration of this honorable court, which everybody must talk about. As a lawyer, from the first day, what we are taught is that we must address injustice. And we must address injustice by going to court of law. We can give a hearing, a trial to an assassin, to a criminal, to a terrorist like Kasab for 2 to 3 years. We can hear about Right to Privacy Act. There is an aspiration of a terrorist that he should be heard at 2 p.m., at 2 a.m. at night, whatever we may call it. And that aspiration turns into a reality. He gets a hearing. But an ordinary person, he wants to address a historical injustice which is perpetuating for last 400, 500, 600 years. Can we, as a society, as a nation, as a democracy, say that no, this law would prohibit your redressal, you would not be able to come to the court? This is not something which is why we cannot allow a person in Varanasi or in Mathura to come to a court and say that, look here, there is an historian, he has written, Richard M. Etten, in his book, India in the Persianate Age, 1000 to 1765. I'm quoting him because people respect foreign scholars more and Indian historian less. Less people may think about it. Why can't he go to the court and quote him? Why can't he quote Sitaram Goel? Why can't he quote historian like Masire Alamari and say what has been done? And if he thinks that it is wrong, why can't it be addressed? This is a very crucial aspect. The vires of this law must be tested, if not on any other ground, on this ground that it hits the judicial review principle, which is the basic structure of the Constitution of India. I'll take you all to the provisions. It is very strange. One thing is that the act also, the statement of object and reasons also say one thing. It says, however, since the case relating to the place commonly called Ram Janam Bhoomi Babri Masjid forms a class by itself, it has become necessary to exempt it entirely from the operation of the act. For a particular community, friends, without naming it, for many there is no difference between Ram and Krishna. It is at a same place. You cannot choose a birthplace by the deity. If Ram forms a class, if Ram Janambhoomi forms a class, so does Krishna Janambhoomi as well. And all what a person expects is a hearing. A hearing in a court, like as it happened in Ayodhya's case and Ram Janambhoomi's case, whatever a verdict, this entire nation of 130 crore people respected it because the judiciary's verdict is final, is respected in the country. How can we expect that it will not be followed? There were people, there were conversations going on that there will be eruption of widespread violence in the country. This should not be done. But every single person of this country hailed the decision passed by Supreme Court because it not just right, it is also final. That finality has not come to many quote unquote controversies which are mentioned in the law. They're not controversies, friends. They're bleeding wounds for many communities and not just one community. And all what they expect is that they go to court and they address their grievance. What it says is, and by the 11th day, it is to be seen, the cutoff date is 15th of August 1947. Why this date cannot be 1669? Why this date cannot be 1269? After continuous struggle of 1,000 years of invasions of occupants by foreign invaders. I'm not getting to the debate where people often say that people came and they ruled and they became part of this country. That's fine. But we were being occupied for 1,000 years. On 15th of August 1947, we came to an independent nation, woke to an independent nation with a belief that here we would be heard, we'll be addressing every single injustice which has been done in last 1,000 years. If this cannot be promised, then what for the entire purpose of democracy to be held for is? The definition parts defines only 3 sentences. It says commencement of the act and 2 words, conversion and place of worship. And conversion means all grammatical variations include alterations or change of whatever nature. And then section 3, the vires of section 3, 4 and 5 are under challenge in Supreme Court. It says no person shall convert any place of worship of any religious denomination or any section thereof into a place of worship of a different section of the same religious denomination or of a different religious denomination or any section thereof. Friends, courts are safety valve. People do not do justice on streets because they expect that justice would be done in court of law. If you foreclose the doors of court of law, it is a reverse understanding. It goes against the ethos of secularism itself. If you do not give a vent for a closure by way of a proper mechanism, by way of a process of ascertaining facts, by way of a judicial process, it will not come to foreclosure. Foreclosures, when it comes to religion, I'm sorry, cannot be achieved by framing an act. Foreclosures come only in those events when there is adjudication of facts, adjudication of claims, and whatever is the decision that must be followed. And section 4, I'll read it to all. Declaration as to religious character of certain places of worship and bar of jurisdiction of courts, etc. It is hereby declared that the religious character of a place of worship existing on the 15th day of August 1947 shall continue to be the same as it existed on that day. Section 2, subsection 2 of section 4. If on the commencement of this act, any suit, appeal or other proceedings with respect to the conversion of the religious character of any place of worship existing on the 15th day of August 1947 is pending before any court, tribunal, or any other authority, the same shall abate, and no suit, appeal, or other proceeding with respect to any such matter shall lie on or after such commencement in any court, tribunal, or other authority. It should check conscience of every single person who understands law, who practice law every day. What it says clearly, friends, is that you cannot go to court and it hits at the jurisdiction of courts. Can an act say that there would not be any litigation with regard to any aspect which has been done? If the vires are tested, it is for good. And often I have been reading articles for last around 15-20 days where the judgment, the mandate of the 5 judges bench, the constitutional bench of the Honorable Supreme Court of India in Ram Janmabhoomi's case is being referred to. I read that judgment, and the judgment, friend, says that this act, the Place of Worship Act 1991, talks to the past of India and to the future of India at the same time. Friends, but I must tell you with due respect that the vires of the Places of Worship Act 1991 was not under challenge. The matter before the Honorable Supreme Court of India was only with regard to Ram Janmabhoomi Babri Masjid site. That anyway was exempted from this particular act by way of Section 5, as I read in Statement of Object and Reasons. Any observation by the Honorable Supreme Court of India about this particular act has not been tested on the parallels of judicial review, that whether it passes the test set out in Keshwanand Bharti's case, that if any law violates the basic structure of the Constitution of India, it's vires, it is ultra vires, and it cannot stand the scrutiny of Constitution. And any observation by the Honorable Supreme Court of India, with due respect, remains an observation. So therefore, it is still debatable that what the Honorable Apex Court would do in the cases of Places of Worships Act 1991. I think that's all for me today. I'm open to questions.
Thank you for such an insightful session, sir. I sincerely hope that it would make us ponder over a lot of points, and to as we see and as we take law in black and white, we'll be forced to delve into the nuances and nitty-gritties of the issue. I would request the participants, if they have any question, please post it in the chat box. In the meantime, sir, while I was following this issue from last few days, since it has become a national issue, as I could recall the section 3 of the Places of Worship Act, the wordings of the section 3 starts with that no person shall convert any place of worship. So how should we construe this no person? Whether the state can change the nature of the and nature of any place, because if we go by the logic that in the contemporary era, the state is having control over temples, then why can't the state have control over change, or state can change the nature of the worship? So what's your thought on this?
My thought is that your question is very adventurous, and I cannot read state into person and person into state, but it is a wishful thinking if the state can do it. I do not know whether the state can attempt this adventure or misadventure. It would depend on time. But temples must be left to persons and people, and my understanding is that the government should not be interfering in it. And person is just a person like you, me, or any citizen, and this definition of state and governments cannot be read into person. There is
Thank
a
you.
question in the chat box, my
Yes,
friend.
sir. I'll be reading for you. Can Places of Worship Act be placed in the ninth schedule to protect from judicial review?
I do not think so that it can be placed under ninth schedule to protect it from judicial review. That very placement under ninth schedule would make it why the virus would be required to be challenged on that account also. That whether this particular act can be placed in judicial reviews, exempted from judicial review. That itself would be there. That's my.
The other question is, Akshay is asking, could this issue become a precedent to this is a follow up to the earlier question, that could this issue become a precedent to the challenge the whole idea of ninth schedule, which prohibit laws from judicial review.
See, to become a precedent, first it has to come into picture. This question is too at a stage when it is yet to take place. First, this stage is to come, that whether and what Supreme Court says in that matter would depend on it whether it will be cited as a precedent for all cases for judicial review or not. But we are talking about a broader principle of basic structure, judicial review of which forms part of it. And if anything prohibits that judicial review, it must be tested on the grounds of Article 21, due process of law.
Sir, there is one more question which I have received in the chat box. So he's asking whether that section 4 subclause clause 1 talks about that the it is hereby declared that a religious character of place of worship existing on the 15th day of 1947. If we use this provision in the ongoing dispute of Ganwapi Mosque, then whether the religious character of the or the nature of that place would be the shivling if it is found, or whether it would be mosque.
Friends, pardon me saying that. It is, I am not one with the entire thing of proving it with regard to anything. It is noted, accepted, documented, written that it was a temple and it is a temple. So the entire exercise, if you want to do it for a conversation thing, form part of a TV debate, it is one thing, but it is an accepted norm. There is a historical evidence of Indian historians, of foreign historians, of the so-called liberal left, center, middle, all historians, that it is a temple. So there is no question about it. How this thing is, whereas this particular act is a big hurdle that I understand in the entire matter which is going on in Varanasi court. And what the Supreme Court today, the Honorable Supreme Court has said is that the matter would be transferred to the district judge, and the application for rejection of plaint which is filed under Order 7 Rule 11 would be addressed further. What decision comes on it is to be seen. Mr. Dwivedi wants to say something, my elder brother.
Yeah, I can see Padam sir wants to ask some question.
No, I'm not asking any question. I just first applaud Mr. Karan Bhardwaj for giving such a wonderful speech on the topic. And I must add to what Karan was saying about the case, that the case which has been filed in Varanasi, one should be clear that this is not a title suit like in Ayodhya. This is a worship suit, right to worship. 5 ladies have gone to court and they are saying that asserting their right to worship. They say that inside the mosque premises, Lourdes Parvati's is there and we want to worship her. So that is the question, and this is like Karan earlier said in the speech, that the question of worship is not barred under the Places of Worship Act. So there's no change in the nature of there's no such step to change in the nature of the building or whatever the monument is. So this is just not a title suit, but a title suit to worship. So that is the difference between two suits, the basic difference.
Perhaps that is the reason that the Honorable Supreme Court today observed that ascertainment of right to worship cannot be barred by the Places of Worship Act. In the backdrop of this particular case.
Thank you, sir. Is there anyone else who wants to ask any question? So with this, we come to the end. Indeed, Karan sir has made us realize that a student of law is as good a student of history as of politics. So on that note, I would like to pay my sincere gratitude to both the speakers, Honorable Advocate General Shri Baldev Mahajan sir and Shri Karan Bhardwaj sir, for joining us on such a short notice and enriching us with their experience of litigation and discussing about two crucial issues in the contemporary discourse. As I can see, there are members of BAR who have joined this session. I pay my sincere gratitude on behalf of Think India to the senior members of the BAR. I can see Padam Khan sir is here and other members who have been a constant source of inspiration and support for Think India. We are very grateful for all the dignitaries who are present in this meeting today. And with this, we come to the end. Thank you so much, sir.
Thank you so much.
I hope that we would be able to organize such sessions physically in Chandigarh very soon.
Thank you. Thank you so much. Imagine. Thank you. Thank you, everyone.
Thanks to the participants.
Thank you, India. Thank you.